Hello viewers, this is attorney Naresh Gehi, and today we are going to discuss about easy ways of getting the green card. Over the years, I've received many calls from viewers who have said, Mr. Gehi, I'm illegal in this country. Mr. Gehi, I'm legal in this country, but getting a green card is very difficult. And can you tell me which is the easiest way of getting the green card? So based upon the requests from viewers as well as from the several phone calls and the emails we've received, we've decided to talk today to our viewers about easy ways of getting the green card. And with me today, I have my senior paralegal, Sandeep Nair, who will be joining me on today's program, and we'll be talking a lot about the questions and answers that pertain to easy ways of getting the green card. Hello, Sandeep. How are you?
I'm great, Attorney Gehi. It's nice to be with you today.
Are you ready with a lot of questions for our viewers
We
today?
have tons of questions for you.
All right, so let me just, Sandeep, let me just give our viewers a basic background as to what are the easy ways of getting the green card, and based upon all the questions that you've received in the, in the numerous emails that you've gotten, as well as the phone calls that you've received, I'm sure you compiled your questions. So we'll try to make life as easy as possible for people to understand as to how they can acquire the green card, even if they are legal or if they're illegal in the United States. So friends, let's start with this particular issue. What happens when a person becomes illegal in this country and if he is not grandfathered? And I'm also going to make life easy for people who don't understand the meaning of the word grandfathered under the immigration laws of the United States. If you're illegal, it can be very difficult for you to become legal in this country. This is because after the passage of the 1997 IRA Act, Congress made it very difficult for illegals to become legal in this country. However, there are certain exceptions. So who can benefit from this program and who are the people who will be benefiting? That's what you're going to focus on today. Now, let's take a simple example that you came to this country on a visitor's visa and you have overstayed your visa, and you don't have any other application pending before immigration at this time. The simple answer to your question is that if you are single in this country, consider getting married to an American citizen. Consider getting married to a US citizen, yes. Now, why is that very important? That is important because if you get married to an American citizen, the good news for you is that since you entered with a B1, B2 visa, I'm just being very specific here because, for example, if you entered on a C1D, you cannot even get your green card over here. Now, you came in on a visitor's visa and you overstayed, even if you're a national from India, Pakistan, Bangladesh, or the UK, it doesn't matter. Now, you have overstayed your visa, you want to become legal. Get married to an American citizen. Now, after you get married to an American citizen, what happens? After you get married to an American citizen, the good news is that you qualify under the immediate relative category, which means there's no waiting period. So if you apply for your documents based upon the immediate relative category, the good news is that you may qualify for a green card within 5 or 6 months. Now, Sandeep, I'm sure this is one of the questions that has intrigued you for a very long time. And is there anything else you'd like to add on to this if we missed something on this particular issue?
Is it important to have an I-94 arrival departure card for applying for a green card? Will that affect me if I lost mine?
The answer to the question is, Sandeep, that let's put it this way, that even if you lost your I-94, and I-94 is a document which is actually attached to your passport when you enter the United States, means at the port of entry, which means that if you get off at JFK or if you're getting off at any other airport in Atlanta or at Dallas airport or any airport, the immigration officer gives you a document which is known as an I-94. Now, sometimes people lose the I-94. Remember, that's a very important document because if you lose that document, we will have to reapply for that. But the biggest and the most important thing is that even if you have the visa page, we can try to look at the I-94. And if you're getting married to an American citizen, you can, which means yes, you can get your green card in the United States without leaving the country.
Attorney Gehi, if I'm a student here on an F1 visa, is there a path towards a green card?
Yes, there is a path towards a green card if you are on a student visa in this country. Now, if you're a student in this country, what can you do? For example, you have a master's degree, all right, and right now India is very much backlogged. And if your employer at the stage, you have a ready, willing, and able employer who's very much interested in your skills, and this particular employer wants to sponsor you directly for the green card. The good news is that right now, for example, the EB2 category is current. And if he applies on the EB2 category, and if you're not from India and from of those countries wherein there's a backlog, you can still qualify for a green card. So which means you can directly apply for adjustment of status by filing the I-140 and the 485 together, I believe, once if the labor is approved at this point of time. Now, there's another important thing which I want to let my viewers know. Sandeep, you had asked me this question about if a person is on a green card and if he gets married to an illegal, how can they benefit, I believe.
Right.
Now, if you are illegal in this country and you're getting married to a green card holder, and you say, Mr. Gehi, right now, with a lot of difficulty, I found a green card holder and I tried my best to find a US citizen, but either the woman was too beautiful for me or the guy was too handsome for me, and I didn't want to get married to him because I had this thing that he may leave me. So finally, I'm compromising by getting married to this wonderful man, and he's a man of many parts, and right now he's a green card holder, unfortunately. Should I consider getting married to him if I came in on a visitor's visa and I'm illegal here? Now look at the question. This is a woman who's telling me, Mr. Gehi, I came into this country with a visitor's visa, and I was very little when I came into this country. And I live in Atlanta at this point of time. What should I do? And if I'm getting married to an American citizen? If you get married to an American citizen, or even if you get married to a green card holder now, you're getting married to a green card holder. The good news is that there's a saying in English that something is better than nothing. So which means if you get married to this green card holder, later on he can become a citizen and you can still qualify for a green card in the United States. The moral of the story is it's not that bad to get married to a green card holder, because sooner or later this green card holder can become a citizen and you can qualify for your status in the United States.
Attorney Gehi, in relation to green cards, what is considered a bona fide marriage?
Bona fide marriage is a very interesting concept under the law. And under the law, a marriage has to be bona fide at the time it was entered into between the parties, which means the date when you entered into the marriage, you have to prove the fact that you married this particular man or this woman with the intent to live your life together. With the intent to live your life together. And I've tried many cases in this regard wherein people have had issues regarding proving the marital relationship. And if you prove that you are married to each other for love, then you can still qualify for a green card. I had a question from somebody that I've received very recently. Mr. Gehi, I'm married and I'm a doctor by profession. And my husband is also a doctor. But we live in two different states. Can I still get a green card? Yes. The case law is very clear on that point. It is not necessary for both the parties to be living together, even if you're living separately. But your intent to live as husband and wife and to have a life with each other is more important than actually living separate. Which means even if you're living separately, the bottom line is that if you love each other and if you both have intended to establish a life together, you can meet the burden and still qualify for a green card.
In that regard, what
Isn't
kind of...
that interesting, Sandeep?
That is very interesting.
Because generally people think that if they don't get if they're living separately, they can have a problem. It all depends on how these cases are argued. You need to have a fantastic legal memorandum in these cases, and if you have a fantastic case and if you have all the evidence put together, then that's not a problem. And the good news about immigration law is that lawyers from anywhere in the country can represent you. Your lawyer can be based in Atlanta, he can be based in New York. It doesn't matter where your lawyer is based. And that is very important, which means sometimes, I've seen these cases wherein you have a case in Atlanta and a lawyer from New York or from New Jersey shows up over there. That is acceptable under immigration law. This is because you can have a counsel of your type, a counsel that you like very much, to represent you in your proceedings. So that is fantastic.
Now, in regards to the green card interview, what will the immigration officer ask me and my wife?
They can ask you anything that relates to the marriage. And that's not an easy task because sometimes I've had clients who meet me, and even we get callers who tell us that, Mr. Gay, what can they ask? Firstly, they can ask you anything they want that pertains to the marriage. And they have a lot of discretion in granting or denying the case. If the officer feels that you have not answered the questions properly, or for example, even out of 10, if you miss 2 questions, that can be a problem because the officer may think that I'm not very convinced with the relationship and the client and this particular person who has appeared before me, John and Jane Doe, has not met the burden of proof. Now, if they do not meet the burden of proof, the sad news is that they'll be subjected to a second interview, and the second interview can be a very harrowing experience. Of course, I mean, you can have a very difficult Stokes interview. We call it the Stokes interview. When you go for the Stokes interview, the couple is separated, and there's a lot of pressure. And I would say that it's a good idea for you to have any kind of legal representation, especially during a Stokes interview. This is because this is my personal analysis. I call the Stokes interview as a do or a die interview. It's a do or a die, because if you fail the Stokes interview, you don't have a case. Then after that, immigration can commence removal proceedings if you fail and if your relief is denied by the Board of Immigration Appeals. Of course, they can commence removal proceedings.
In regards to the green card and applying for the green card, does my criminal history matter?
Yes, it does. The question here is that I have a criminal record. Does that really matter? Yes. Sometimes people tell me, well, Mr. Gay, the issue here is that I had a criminal record in the past, and at this time we went to the criminal court. The criminal judge was very nice. He said that you can go home, you pled guilty, you paid the fine, and you're fine. The answer is that unfortunately, immigration does not care about what was done in criminal court. They independently review the criminal matter, and that can be a very, very, very serious issue for the client. And in this instance, there's no option but the client should resort to any kind of legal representation. This is because there are different types of crimes which are looked upon seriously by immigration. For example, they'll check whether you have a violation, whether you have a misdemeanor, or whether you have a felony, or whether you pled guilty to a crime involving moral turpitude. And if you have pled guilty to a felony, you can be in deportation proceedings. Or even if you pled guilty to a misdemeanor, which you thought was correct to do so, and if that happens to be a crime involving moral turpitude, you can still be barred from the United States on grounds of inadmissibility.
What does moral turpitude mean?
Moral turpitude means a crime involving good moral character, which means that you are not a person of good moral character. For example, you engaged in acts such as child molestation or prostitution, you engaged in fraud, serious kinds of frauds. So these are issues. There's a laundry list of cases on this issue, but this is the best way to know about crimes involving moral turpitude. And once if we have a crime involving moral turpitude, you're looking at a difficult situation, and you'll have to apply for a waiver. And sometimes people have a waiver, sometimes they do not have a waiver. So I mean, in these cases, I think people should consult an attorney of their choice.
Now, let's say my spouse, the U.S. citizen spouse, has a criminal history. Does that affect my case at all?
If your U.S. citizen spouse has a criminal history, it's good for her to see a lawyer, because there may be issues in connection with whether the spouse actually is making sufficient monies, and generally it should not be an issue. But on the whole, my strategy is to look into this cases very closely, because sometimes the husband may have an issue with crimes, so it's better for them to actually review that with any attorney of their choice, I believe.
Now, let's say that I was arrested, but the case was dismissed.
Even if the case is dismissed, immigration still has the right to look at those cases very carefully. We've had cases wherein the criminal matter was actually dismissed, but immigration said, we still have the right and we want to know a lot about this particular matter. So, Sandeep, how about this? Let's take a short break, and we'll be back again with some more interesting news from the world of immigration law. Stay tuned, don't go away.
For all your legal matters, including immigration, bankruptcy and credit card problems, divorce and family law, landlord and tenant matters, criminal and personal injury, call Gahey and Associates for a free initial personal consultation at 718-263-5999.
जब कोई बात बिगड़ जाए, जब कोई मुश्किल आ जाए, तब हम आपका साथ देंगे. Anytime you have a complex immigration matter, remember, मैं हूं ना. Welcome back, viewers, and we are going to continue the second part of our segment, Easy Ways of Getting the Green Card. And Sandeep, my senior paralegal, has some questions to ask me, and these are questions which we have received from viewers like you. So let's take the questions as to how we can, actually make people understand this process in simple terms, I believe.
Attorney Gahey, what would happen if my spouse does not show up to the green card interview and they put me in deportation proceedings? Or
all right, the question here is that what happens, you're married to this American citizen, and at this stage, your spouse did not show up at the interview with you, and you married him with, with a lot of thinking in your life, and you thought that our marriage would work, and you were a victim of torture, and at this time, your spouse, your American citizen spouse, wants to penalize you by not coming with you to the interview, and he wants you to be deported from the United States. There can be some light at the end of the tunnel in these cases. Now, you're married to this American citizen, and you're being subjected to abuse on a regular basis. So the good news for you is that if you are a victim of abuse, you don't need any help from your U.S. immigration, your U.S. citizen spouse. I apologize, your U.S. citizen spouse, which means you're married to this American citizen and you're constantly being subjected to abuse, and he's also telling you repeatedly that he's going to get you deported from the United States. The good news is that under VAWA, which is known as the Violence Against Women's Act, under the battered spouse provision, the good news is that you don't need any help from your spouse. You can self-sponsor yourself to the green card, for the green card, which means that you don't need any assistance from him, and you need to just show that you have been subjected to extreme cruelty. Now, that's a pretty high standard, and for example, we had a case of a woman who actually was married to this person, and listen to this, they went for the interview, and the spouse made a statement in writing that he married her with the intent of only getting her the green card. Look at this. It was a very serious issue. You met the spouse, the woman in this case, and she was in tears. And she said that he deliberately did it. So after that, we looked into the merits of the case, and we realized that this was actually a bona fide marriage, and the husband was trying his best to get the wife deported from the United States. The matter went before the immigration judge, and we were able to prove by the amount of evidence which we had in the case, with the plethora of evidence which we had, that this marriage was actually bona fide, and the judge agreed with us, and this particular woman qualified for a green card under the Violence Against Women's Act, and she is currently a permanent resident of the United States. So remember, folks, if your husband or your wife, it can go in both ways, is subjecting you to cruelty, there's nothing for you to worry about. You can still qualify for a green card if you can prove extreme cruelty in your case.
so does that mean if I divorce my U.S. citizen spouse, can I still pursue the green card process, or does the petition get canceled? What happens in that situation?
The very first thing is that if you're a victim of abuse, then you don't have a problem. You can still continue the case, and at this stage, you will need legal representation. Or secondly, if you don't have any other relief, for example, you break up the relationship because of no fault issues, which means there was no fault from either party, you can still have other forms of relief, which means suppose in case if you're from a country wherein you fear persecution because of your race or because of your religion or because of a membership in a social group under Section 208 of the Immigration and Nationality Act, you can still qualify for a green card. So the bottom line is that anytime you are in troubled waters, if you are in troubled waters, there's no substitute to legal representation, especially because sometimes what I've seen over the years is that people actually they think they don't have rights, but they do actually have rights. So therefore, I mean, for example, there are people who are in deportation. You get a notice, from immigration, and let them know very clearly that you want to be represented by a lawyer, because you may have relief. And if you sign that document that you're waiving your rights to counsel, then the sad thing is that you can be deported from the United States.
What is the difference between the 2-year conditional green card and the normal green card?
What is the difference between the 2-year conditional green card and the normal green card? Generally, when you get married to an American citizen, and if your marriage with the American citizen is for less than 2 years, then under Section 216 of the Immigration and Nationality Act, you will get a conditional green card, which means the green card is conditioned upon the fact that you're going to continue to live your life with the American citizen. That's why immigration gives you a 2-year green card. Now, after that, before the end of 2 years, you have to file for the removal of conditional residence, which means under 216, you have to file for the removal of conditional residence 90 days before the expiration. And when you file the documents, be very careful, because if you have missing documents, if the officer is not convinced at the interview, the problem is that he will deny the case and ask you to see an immigration judge, which means deportation proceedings are being commenced against you, and that can be very serious.
Attorney Gay, you mentioned earlier persecution. What do you mean by political asylum, and who qualifies for political asylum?
Your question is that, what do you mean by political asylum and who qualifies for political asylum? Political asylum is governed under Section 208 of the Immigration and Nationality Act. And under this particular provision, if you fear persecution because of your race, membership in a political group, because of your religion, then you can qualify for political asylum. And which means that if you're a member of a political party, for example, if you go back to your country and you have this political opinion that the country should not be carrying on their business in a particular way, and the leaders, for example, are corrupted in that nation, and you've been subjected to torture for standing up against them. A simple example is that, if you are a leader in a country and you're fighting because people of your race are being killed, or because your political opinion is very much antagonistic to other people out there, to the political wing out in the country, that can be qualified as your political opinion. Now, another thing is that, let me clarify. Now, let's take an example of religious. If you belong to a minority group, for example, we had a client from Pakistan, and he was a Shiite Muslim, and he said that he could not practice his religion properly because there were some Sunnis, who were very highly connected, and they were actually troubling him, and they had also beaten him up. And the good news is that we reviewed his matter, and in that case we applied for political asylum, and this gentleman was able to prove that he has suffered past persecution. The good news about past persecution is that once if you prove past persecution, then under Section 208, the burden of proof actually shifts on the government, and your case becomes much easier. And that's how this person had actually witnessed, and I believe he wound up actually succeeding in getting his asylum approved in the United States.
Now, just a question from some of our viewers. If I'm currently illegal in the country, am I able to get a work permit and work legally?
No, if you're illegal in this country, you cannot get a work permit, and you're not allowed to work under any circumstances, directly or indirectly.
Attorney Gay, it looks like you went through all the questions for today. Do you have anything additional to say?
I just request my viewers to make the best use of the recent Obama policy, especially if your spouses are illegal in the United States. For example, if they crossed the border and came to the United States, or if they've been ordered deported. This may be the best time for you to actually review the cases and see whether they qualify under the program. Because as you've seen that we've been getting some kind of relief from immigration after a very long time, and make the best use of it, especially the Obama policy at this particular point of time. And be safe, don't get into deportation, especially because we've handled a lot of deportation cases, and I must tell you that it's very complex, especially things can be really complex when you get into deportation. And my final word to my viewers is, stay legal, and if you're illegal, become legal in this country. So we'll be back again with some more interesting news from the world of law for the benefit of our viewers.